We are live.
Oh, so you all have this bill somewhere, sure.
There is a section, a side by side now, should make it easier to see the differences between 44. That's the Senate and the left the House.
So why don't you just tell us what the bill is, remind us? They all kind of run together by this point.
This is the miscellaneous bill relating to impaired driving laws. And so the changes between the House and the Senate proposal of the amendment. The first one is in section 1, 4 VSA, section 33, subdivision A8, which makes changes to align with the federal anti-masking statute. So where you, there's a question on the Senate floor, like masking, does that mean basically hiding convictions from CDL convictions or convictions related to CDL licenses because they're federally issued licenses. There's a federal scheme of sort of public protection because there's more of a need to kind of know about CDL drivers' driving records because they drive frequently and big rigs. And so this language is derived from a federal regulation just so that we are compliant with the federal regs.
Right.
So that's the first change.
We've had DMV and state's attorneys and defender general and the court all in saying that.
Yes, and this
changes.
particular language was proposed by the DMV general counsel. So they're bought in. As far as the next change, this is in section 2, which amends 23, chapter 13, subchapter 13. It makes a change to section 1201, sub J, which this body had added, but there's a slight change in the wording. If you look in the first 2 lines of subsection J, it left the House to read that a person suspected of violating this section shall not refuse to submit to the collection of an evidentiary blood sample. So, and then in the Senate, they proposed that a person suspected of violating this section shall submit to the collection. Again, this is an affirmative obligation on the subject of blood test to submit. The reason why the language changes because the Defender General raised some issues over implied consent, seeing how refusal is the antithesis essentially of consent. So to move away from any implication, we change it to submit. So the force and effect is the same, but hedges against any potential implied consent issues.
So there's a warrant to get for the blood.
Right.
Person refuses, they're just charged with refusal.
They could be that's addressed in the next change to highlight. And so if you go down in section 1202, it's actually on the section by sec or the side by side. It's really the very last page. That when it left the House, you had created that criminal refusal penalty, where it just said if someone refuses the collection of an evidentiary blood sample when a warrant for that person's blood is issued, they could be charged. The Senate proposes a change to knowingly hinders the collection of an evidentiary blood sample. So the difference is that refuses could be considered a strict liability crime. Knowingly hinders creates a mental element where the person essentially has to be aware or practically certain that their actions could lead to a result of hindering the collection. So this gets at the situation that was discussed in committee, where if someone's too incapacitated to essentially know what they're doing, the language as it left the House, the Senate discussed that if they're just essentially too incapacitated, could that be considered a refusal? And do you really want to criminalize somebody at that point? So the policy decision that they made is that they have to have awareness of their actions to actually hinder the collection to criminalize that conduct rather than just being too incapacitated and kind of being limp on the stretcher or whatever.
So criminalize as in an additional charge.
Right. So it would still be, it's still criminal. The way it's treated is the same. It's just the mental element required to bring the charge is elevated. So on the House side, your proposal, it would be strict liability. Anything that could be considered a refusal could be charged criminally. The Senate proposal is that the person has to essentially know what they're doing. Knowingly hinder the collection in order to be charged criminally. So that it's still a criminal penalty, is just the mental threshold to charge them is elevated in the Senate proposal.
So if they're too incapacitated to either refuse or agree to a blood sample, how are they still charged with the DUI?
So they could still be charged with a DUI. This is the refusal, the criminal refusal, which could be, because right now that can be charged if you have a second DUI or other circumstances. This creates it for
You wouldn't have the evidence to charge them with a DUI and
DUI is a separate charge.
Do it by operation, not by test.
Right. And there's also that kind of catch-all impaired driving provision where if they're impaired to the slightest degree, that's still at play here. But the DUI charges are separate from the criminal refusal charges. And so what is consistent between both chambers is that you still have the basis to charge a criminal refusal for refusing or hindering a blood draw. The difference between the two proposals is that in the House, it's a strict liability crime. And in the Senate, they're proposing that you have to have a mental state of knowing what you're doing, knowingly hindering the collection. So that's the difference. Does that make sense?
Any questions for Ben? Those were all the changes from what I understand. And when we had this, we took quite a bit of testimony way back in February, I think. We passed it out at 11-0. Any concerns, questions on that? Not seeing any, I take a motion to concur with the Senate amendment to H44.
so moved.
Second?
All right. Any discussion? Not seeing any. All in favor of concurring, please raise your hand. Right, and all those opposed. All right. So you have you're missing two people, and so it can be 902.
I'll do something tomorrow.
And you get to report.
You get to, it's very exciting.
Yeah.
902.
You have the side-by-side to
I'm looking at it right now.
through it. So,
Yeah,
we can chat if you'd like.
I might just need an explanation on the first one again.
Sure.
All right, so we're gonna do also, are you prepared to tell us about that big change in H222?
Yes, I am prepared.
Voted out, third reading, it's on its way. I think we'll get the news handled tomorrow, so be up on Friday morning probably. To explain this amendment.
Sure. So
Do we have that here somewhere? Or can you put it on the screen?
I can, bear with me.
I mean, it's like 5 words, so.
Right.
It's,
No, it's just a matter of pulling it up and logging on.
oh, here we have it, right here. All right.
Right.
All right, so.
Great.
Great.
Yeah.
Thank you.
Line one.
Remind me out of that scene of
Yeah.
last time's bridge on high with the sheets fresh off the printer. Everybody just
Yes.
All right, over to you, Ben.
Sure. So for the record, Ben Novogroski, from the Office of Legislative Counsel, filling in for our esteemed Michelle Childs. So before the committee is a proposed amendment from the Senate, which really makes one small change in section 2, in 15 VSA section 1103 C2J. In the second sentence of that provision, after civil contempt proceedings, it's added that pursuant to Rule 16 of the Vermont Rules of Family Proceedings, that rule is the civil contempt process in family court. So the way that this would sort of interact now is, if you look at C2J, that amendment permits the court to require the defendant to complete a domestic violence accountability program approved by the Council on Domestic Violence. And basically what would happen is an explicit cross-reference now to the contempt procedure, because the failure to comply would not be a crime, but the defendant may be subject to that Rule 16 proceeding. Thought I had the answer for you.
Thank you, Becca.
Tracy?
So any questions or concerns for Ken? Seems pretty straightforward. The vote, we took a lot of testimony on this as well. The vote before was 902. Bernard and Christie were missing. But if there's nothing else, I'll take a motion to concur with the Senate amendment to H222.
Second.
Any discussion? Not seeing any discussion. All those in favor of concurring, please raise your hand. All right, we're all set, and you're set to report that out on whatever.
That was, I didn't look at 902.
It was 902.
Again, 90.
Again, yeah. So tomorrow morning we have, we're doing another bill that we're going to continue to work on. I have a couple witnesses on 223. Then 10 o'clock, whoever wants to join for the signing ceremony for 41. And then I do have 11 o'clock, and I have a question, I guess. At 11 o'clock, I put down committee discussion on Ken's favorite bill, H411. And I'm wondering if we should, I'm wondering if we should have Tucker Jones come in and essentially go over, like, what do we still have left that we haven't covered elsewhere? What's your pleasure on that, Ken?
Have Tucker, you're gonna have Jay. If Jay is available, just come in for,
Yeah.
I mean,
I'll see if she's available.
I mean, I'm kind of like blindsided that you're even looking at it. It's
Well, you've
like,
been asking for the last 3 months.
no begging.
You don't beg.
Oh, that's true.
So should I reach out to Jay?
Yeah, just say if it's not Jay, Tucker, or somebody on very short notice, we'll move it forward. I really appreciate you looking at 411. What do you want?
Nothing. No, I just want to see what we have left. So when I talked to Jay at some point during the session, she was talking about, and maybe it was when she was testifying, that 411 was kind of their scorecard of the many things they wanted, and they understood that they were being done by the Senate on some things and from the House on some things. So we've done extradition, we've done sealing, when we've done the inebriate, and I just want to see, well, what's left to continue to think about, and perhaps some further work in the off session, kind of to set us up. So that's kind of the goal for that.
I can't remember, did they have the, where we seem to be hung up on, the work, the work crew? Was that in part of that bill, or
No,
we'll be
no.
talking about that after?
And we can get it
After.
I just,
that's an ongoing thing going on between corrections and us. That's where we are. Anything else? Otherwise, we'll adjourn until tomorrow at 9.